Doctor, my baby has a high fever and has swelling on his neck. He keeps crying and looks uncomfortable.
Okay, so let me check first. I think it's just a normal infection. I'll just prescribe him antibiotics and I'll get to him.
Is it serious?
To me, actually it's manageable. Just give him the medicine. I'll give you later, and just keep monitor him. If it became worse, then just come back to me. Right?
Okay, thank you, doctor. Swelling is getting bigger and he's struggling to breathe.
Madam, the condition is quite critical. It's a sign of a deep stress and his airway may become blocked. He needs an immediate admission.
Doctor, we are facing financial problems. We cannot afford the deposit for admission. We need some time to think and arrange things. So I think it's okay, doctor. Thank you. Doctor, please save my son. He cannot breathe properly.
His condition becomes severe and the swelling becomes massive and block his airway. I think we need oxygen support now. Admit him.
What has this surgery not happened yet?
We are stabilizing his conditions first. Operating immediately without a proper imaging is risky. We need to understand the infection before surgery.
But this is getting weaker.
We are monitoring him closely.
All rise. The Court of Appeal of Malaysia is now in session. Calling Civil Appeal Number T01388808 of 2020, Kuala Terengganu Specialist Hospital Serjant Berhad and another against Ahmad Thaqif Amzar bin Ahmad Huzairi, an infant claiming through his mother and litigation representative Majdah binti Muhammad Yusof, together with consolidated appeals. Silence in court.
May I hear your appeal statements from the counsel?
May it please Your Honour, I am Mr. Christopher Wong, together with my learned friend, Ms. Amira Azman. We represent the appellant in this matter, the infant plaintiff, Ahmad Thaqif Amzar.
May it please the Honourable Court, my name is Harisa and I appeal on behalf of the first and second respondent, Kuala Terengganu Specialist Hospital and Dr. Zainal, alongside the Senior Federal Counsel representing the Government of Malaysia.
Counsel for appellant, you may proceed.
Much obliged, Your Honour. The appellant calls our first witness, Madam Majdah binti Muhammad Yusof, to the stand.
Please raise your right hand and repeat after me. I solemnly declare
Solemnly declare
that the evidence
that the evidence
I shall give to this court
I shall give to this court
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Madam Majdah, what is your relationship with the infant plaintiff?
I am his biology commander and is the appointed litigation representative.
On what exact date did you first bring your child to see Dr. Zainal at Kuala Terengganu Specialist Hospital?
I brought him on the morning of 23rd August 2011.
Yeah, see. What physical symptoms did you report to the doctor during that consultation?
He had a high body temperature and a clear heart swelling on the left side of his neck.
See, what diagnostic scans or blood tests did Dr. Zainal perform during that day?
None. He only touched the swelling with his hand, prescribed oral antibiotic syrup, and sent us home.
See, when you returned to the Kuala Terengganu Specialist Hospital on 1st September 2011, due to worsening swelling, what financial demand was placed on you before room admission could proceed?
The hospital administrative desk demanded an immediate upfront cash deposit of 5,000, which we could not afford at a specific time.
See, thank you, Madam Majda. The witness is ready for cross-examination.
Madam Majda, you are required to answer my question strictly with a yes or a no answer. Do you understand?
Yes.
So, during the second consultation on 1st September 2011, Dr. Zainal explicitly warned you that leaving the hospital can carry a risk of upper airway obstruction for your child. Is it true?
Yes.
And despite that medical warning, you choose to sign a refusal form and take your child home. Am I correct?
Yes.
Your Honor, I hold the original refusal form from Kuala Terengganu Specialist Hospital dated 1st September 2011. And I request this be marked as Exhibit D3 titled Refusal of Hospital Admission Form. So, Madam Majda, is it true that the signature on Exhibit D3 belongs to you?
Yes.
And after signing Exhibit D3, you kept your child at home for 5 consecutive days without any professional medical monitoring. Is it true?
Yes.
Thank you. No further question, Your Honor.
The witness may be excused. The appellant calls our second witness, the independent medical expert, Dr. Kavita Mangso, to the stand.
Please raise your right hand and repeat after me. I solemnly declare that the evidence I shall give to this court shall be the truth, the whole truth, and nothing but the truth.
Dr. Kavita, what is your current medical designation and your total years of specialized clinical practice?
I am a senior consultant, pediatric ENT specialist at the University Malaya Medical Center within 24 years of specialized clinical experience.
Have you reviewed Dr. Zainal handwritten clinical logs and prescription cards dated 30th August 2011?
Yes, I truly audited all relevant documents within the medical bundle.
In your professional expert opinion, what diagnostic procedure is mandatory when an 11-month-old infant presents with high fever and acute neck swelling?
The universal standards of care dictates an immediate soft tissue ultrasound scan. Discharging an infant suffering from an unmethod deep space neck pathology with only standard oral antibiotic syrups constitutes a critical diagnostic failure.
Thank you. The witness is available for cross-examination.
Dr. Kavita, please answer my question strictly with a yes or a no answer. So, a localized early stage neck swelling can clinically present identically to simple benign lymphadenitis on day 1. Am I correct?
Yes.
So, when a deep neck abscess is kept at home for 5 full days, that delay will drastically expand the tissue mass and also compress the trachea, correct?
Yes.
Thank you. No further question, Your Honor.
The witness may be excused.
The respondent called our first witness, Dr. Zainal bin Bachir, to the stand.
Please raise your right hand and repeat after me. I
I
solemnly declare
solemnly declare
that the evidence I shall give
that the evidence I shall give
to this court
shall be the truth,
the whole truth, and nothing but the truth.
and nothing but the truth.
Dr. Zainal, what urgent clinical finding did you establish when the infant plaintiff came to you on 1st September 2011?
So I identified a massive deep neck abscess causing an immediate threat, upper airway obstruction. I also ordered urgent admission, but the parents explicitly refused and executed the refusal form.
Thank you. No further question, Your Honor.
Dr. Zainal, look at your clinical logs for 30 August 2011. You did not order any radiological ultrasound scan on that first visit, correct?
Yes.
You chose to discharge an 11-month-old infant with an active neck pathology based on manual touch alone without viewing the underlying tissue pathology. Am I correct?
Yes.
Had you performed an objective ultrasound on 30th August, the deep abscess would have been detected immediately before airway compromise developed. Am I correct?
Yes.
But you chose not to test it. No further question, Your Honor.
Your Honor, the witness may be excused. The respondent called our second witness, Dr. Rahimah Ahmad, a government expert from Hospital Sultanah Nur Zahirah, to the stand. Please raise your right hand and repeat after me. I solemnly declare that the evidence I shall give to this court shall be the truth, the whole truth, and nothing but the truth. Dr. Rahimah, can you explain the clinical state of the infant when he arrived at the emergency unit 5 days after leaving Kuala Terengganu Specialist Hospital?
The patient arrived in an extreme advanced state of airway compromise, leaving the abscess untreated at home for 5 days, allowing it to be heavily deform his tracheal structure, causing our clinical team to execute immediate crisis stabilization protocols.
Thank you. No further question, Your Honor.
Dr. Rahimah, look at the Hospital Sultanah Nur Zahirah admission charts. The infant arrived at your hospital ward at 9 a.m. on 5th September 2011, correct?
Yes.
Your surgical unit left this infant lying in a standard ward bed for over 24 hours without performing any emergency surgical drainage of that pus. Is that true?
Yes.
You made a critically ill child wait in a ward until his airway completely collapsed and caused cardiac arrest right inside your hospital ward. Am I correct?
Yes.
So you monitored him while he was actively suffocating. No further question, Your Honor. Both parties rest their case. Your Honor, the medical timeline shows legal liability. Dr. Zainal absolute omission of a diagnostic scan on 30 August 2011 set this disaster into motion. And the 24-hour surgical delay at Hospital Sultanah Nur Zahirah served as the operational cause of the hypoxic brain damage. Under Malaysian thought principles, an innocent infant cannot have his compensation slashed by 30% due to an independent refusal form executed by his parents under financial duress. We pray that the contributory negligence finding be set aside in full and that the future care multiplier be extended from 16 to 23 years.
Your Honor, the defense case is entirely secured by Exhibit D3. Dr. Zainal fully discharged his duty of care by ordering immediate emergency admission on 1st September 2011. The parents consciously executed a refusal waiver and delayed public treatment for 5 days. Under Section 12 of Civil Law Act 1956, the 30% apportionment for contributory negligence is fully justified and must be affirmed. Furthermore, the claims for private therapies must be rejected as these exact treatment are available cost-free in the government hospital.
We have evaluated the clinical evidence, statutory frameworks and oral testimonies. This court finds that Dr. Zainal breached his fundamental duty of care on the 30th of August 2011 by omitting a standard diagnostic ultrasound on the infant's neck swelling. However, regarding the cross appeals on contributory negligence, the execution of the refusal form marked as Exhibit D3 establishes that the parents were fully appraised of the life-threatening risks to the child's airway. Choosing to keep a critically ill infant at home for 5 full days against explicit medical advice falls far from below the standard of care expected of reasonable guardians. Therefore, this court unanimously affirms the trial judge's apportion of liability. The distribution of 50% liability to Dr. Zainal, 55% to the government hospital, and 30% contributing negligence to the parents stands firm. Regarding quantum and future damages, we vary the High Court award as follows. We increase the future care multiplier from 16 years to 23 years based on joint medical expert testimonies. We set aside the 100,000 aggravated damages as there was no proof of malicious intent. Finally, we reject the claims for private medical therapies since these exact treatments are available cost-free at the public government hospitals, and the global award is varied accordingly. Court is adjourned.
All rise. Court is adjourned.